Fani Willis, the DA for Fulton County, who brought charges against over 30 people on this electors issue and the phone call issue, putting that all aside right now because her entire DA's office has been disqualified from the case involving President Trump and the other defendants. So because of the fact that she brought Nathan Wade in as a special counsel who had no special or unique knowledge of a RICO case, nearly $1 million that they used, and it looks like they lied about how they were utilizing the funds together. I think it was $768,000 that his firm was paid to be the special counsel that he didn't have a specialty in, and they used it for trips. Remember, they tried to hide all of that. They tried to hide their relationship. The lower court, the trial court, basically said there was the appearance of impropriety, but this needs to likely be seen by potentially an appeals court. This was, of course, appealed. And the Georgia Court of Appeals, in a 2-1 decision, said Fani Willis out. But it's not just Fani Willis who's out. It's the entire prosecutor's office. So Fulton County DA's office cannot be involved in any more of this prosecution. Now, what happens next in Georgia? Briefly for you, it goes to what's called the Prosecuting Attorneys Council of Georgia. They have a membership. I think it's 9 different counties.
9 from across the state.
County DAs. They can decide to dismiss charges, or they can appoint someone who is a prosecutor from another county to decide what to do.
I do not see any way they bring a charge based on the same charges she brought in the RICO case from a new DA. I just don't see it. Now, another thing that's important in the opinion, and I think this goes to the heart of what we argued in the case, was that, remember, the trial court judge said there was an odor of mendacity surrounding this, but he didn't think it rose to the level of disqualification. Obviously, the Georgia Court of Appeals, and that's what we wrote in our brief, thought it was enough for disqualification. The disqualification here is also significant because it goes back to the pre-indictment investigation. In other words, what the Georgia Court of Appeals is saying is her office should not have been involved even in the pre-indictment issues. So it puts into question the entire process. But I think the good news for the president-elect as well as the incoming team, it takes this case off the plate. And there is no way that anything is going to happen anyway, but this certainly doesn't. And for the other defendants, this is really good news.
Even the language you hear is very important when you're understanding this. It says, after carefully considering the trial court's findings in its order. So their information they're using is what Judge McAfee had put forward. It wasn't, they didn't go out and do their own fact finding, their own court briefings other than what we filed and things of that nature. And they didn't even get to oral argument, remember. So they're relying on the briefings and what the lower court had decided. And it says, we conclude that it erred by failing to disqualify DA Willis and her office. The remedy crafted by the trial court to prevent an ongoing appearance of impropriety did nothing to address the appearance of impropriety that existed at times when DA Willis was exercising her broad pretrial discretion about who to prosecute and what charges to bring. While we recognize that an appearance of impropriety is generally not enough to support disqualification, this is the rare case in which disqualification is mandated, and no other remedy will suffice to restore public confidence in the integrity of those proceedings. So when you hear that, Jordan, they're talking about the pretrial issues, the appearance of impropriety, and they're saying that no other thing can happen to address this other than disqualification of her in her office.
The real issue here is that Fani Willis brought a flawed case in the first place. And so she's engaged, if you will, in a pattern and practice of conflict of interest prosecutions. And this commenced well before bringing the charges against Donald Trump. So if you go back to 2022, she brought a case against an individual who was running for lieutenant governor, and she appeared in support of a fundraiser for that individual, but then worked with a grand jury to prosecute that individual. That is a clear and unmistakable conflict of interest. And here we also have evidence of a conflict of interest. she hired her ex-lover to bring charges against Donald Trump. Then she went to Miami with the ex-lover, to Belize, and to other trips, Napa Valley. And so she profited from this transaction brought against Donald Trump. So I think at the end of the day, she was a flawed individual. And I would argue that many of these individuals who bring these cases, including Alvin Bragg in New York, Jack Smith at the federal level, they suffer from the Trump derangement syndrome, and they therefore misunderstand basic rules of law. And so I'm glad to see the Court of Appeals in Georgia reach the right result. Of course, she can appeal it to the Supreme Court in Georgia, but I'm quite confident that they will deny her appeal.
This was unique. Usually the court said it would take more than the appearance, that even having Nathan Wade and getting rid of Nathan Wade might not be enough in normal cases to be disqualifying. But in this case, it was such a huge part of the case because he was supposed to be the special counsel that put together the RICO charges, that led the RICO case here, because doing that is a specialty in the law, to put together or to defend a RICO case. And the reason this became scandalous was twofold. One, he had never done a RICO case before and got paid $680,000 from the county to do so. And then two, it looks like that they were commingling and utilizing those funds for vacations together, and that they had a relationship that they were trying not to disclose to the courts that was disclosed. And obviously, Nathan Wade was removed from the case, but then the Georgia Court of Appeals said that's not enough. This goes all the way back to even the pre-indictment. That the appearance here met the standard for whole entire office to be removed. If you talk about, disbarment and all these other issues, that's up to the Georgia bar and up to Georgia attorneys who can bring those kind of challenges. That's totally separate from the criminal process here and court process we are in. That's the second time for her. So I think also voters have to decide, are they going to keep electing these political DAs who may be able to bring, scary looking charges and be like, even Jack Smith at the federal level with these, is a special counsel even okay under the Constitution? How can he have the authority that a U.S. attorney that has to be confirmed does not? But again, I think they have to think twice now before they bring these politically charged prosecutions that look and appear to the public as just that,